Good morning. Welcome to the monthly webcast presented by Pro Bono Partnership of Atlanta. We want to begin by thanking Georgia Legal Services for hosting this webcast and making it available on its website. The information provided during this webcast does not constitute legal advice and is for informational purposes only. My name is Tracy Blanton, and today I will be talking about hiring and firing, playing within the legal boundaries. And I think all of you have access to these slides that I'm going to be referring to throughout the presentation today, so I will try to let you know where I am on the slide so that you can follow along. Looking at page 2, the mission of the Pro Bono Partnership of Atlanta is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. Slide 3 is a list of qualifications for the Pro Bono Partnership of Atlanta eligibility and other information, and this is for your reference. The website, you can access a lot of resources and information about the organization at www.pbpatl.org. Okay, moving into the presentation on slide 4. Liability for unlawful employment practices. This is why we are here today. And this is just to give you an overview about how much money some corporations and organizations have paid out for unlawful hiring and termination practices. So hopefully this will motivate you to pay attention during the presentation today instead of playing on your computer or snoozing, going to get coffee or whatever. So I'm going to try my best to give everybody some practical pointers and hopefully make you think like a lawyer as you are going through your human resources management practices. So recently, and these cases referred to here all occurred within the last several years. Most of them were brought by the EEOC or resolved at the EEOC stage. One company, looking at the first bullet, has agreed to pay $3.13 million to provide job offers and training to resolve allegations of race discrimination related to the use of criminal background checks. Now, the allegation here was that the organization had a policy of hiring workers just who had arrest records and who had criminal records for minor crimes. And the EEOC has long held the position that just precluding applicants just based on the existence of a criminal record has a disparate impact on minority applicants. And I've been informed that recently, within the last couple days, the EEOC has issued a directive, pretty extensive, regarding the use of criminal background checks in the hiring process. They are necessary in some organizations and for some positions, and they're very useful as well, and we'll talk a little bit later about how we can use those records and why we would use them. Another company has agreed to pay $3 million and provide training to resolve allegations of age discrimination and termination. Now, this particular company, the allegation was that they unlawfully laid off employees over 45 to make room for younger leaders in the organization. Now, keep in mind, however, that these organizations that are agreeing to pay in the millions of dollars have a lot of employees. They might be global organizations or at least national organizations. But still, just keeping in mind, I mean, the liability can be substantial for any missteps in the hiring and termination process. One company has agreed to pay $340,000 after withdrawing job offers based on unfounded fears and discrimination. Now, this particular case was against a hospital who withdrew job offers after learning that several of the nurses had latex allergies. And the hospital believed that they couldn't work in an environment, obviously, with the latex gloves and other latex equipment, when in fact there were board allergists who actually came out and said that their allergies would not preclude them from working in the hospital. So a lot of the discrimination laws are to protect individuals and to prevent employers from basing employment decision on unfounded fears. And the ADA is another one of those statutes that seeks to protect employees from employers' fears of unfounded fears. Another company has agreed to pay $225,000 to resolve hiring discrimination allegations based on a statistical shortfall in hiring minority applicants. So again, this is just sort of hopefully motivation for you to glean some insight into best practices for hiring and firing, which I'm going to talk about today. Now, flipping to slide 5, an overview of the presentation. We're first going to talk a little bit about some of the laws that impact hiring and firing decisions, because I think it's necessary that you have a good comprehension of the legal framework in which we're working, so that you understand throughout the presentation why I might advise certain practices to protect your organization. We'll talk about specific hiring practices and termination practices and post-termination practices as we go through the presentation. So the goal is to provide an overview of the legal issues. There are a lot of topics in here where you can drill down into them much further than I'm going to today, simply because it's a time issue. The Pro Bono Partnership has a lot of resources on its website for specific seminars that have been given on some of these topics. And if you have information that I didn't touch on today, please be sure to visit their website and see if there are some resources that might be able to further answer your questions. So my goal today is awareness, and I would like you throughout the presentation to think like a lawyer. Flipping to the slide 6, the legal framework. I'm sure most of you have heard of Title VII of the Civil Rights Act, which applies to organizations and companies with 15 or more employees. Now, for a lot of nonprofit organizations, you might have a lot of volunteers working for your organization, and generally volunteers are not going to be included in that count. Now, if you are classifying someone as a volunteer who is actually an employee, you might have some issues, but true volunteers are not going to be a part of that calculation. The Title VII of the Civil Rights Act protects employment discrimination, or prohibits employment discrimination and retaliation based on race, color, religion, sex, or national origin. It also recently passed the Genetic Information Non-Discrimination Act, which prohibits discrimination based on genetic information. It also prohibits pregnancy discrimination. Now, while Title VII applies to employers with 15 or more employees, be aware that the Civil Rights Act of 1866 applies to all employees. And now, while it is not as broad as Title VII, it does prohibit race discrimination and retaliation. So while Title VII might not apply to your organization, Section 1981 may. The Age Discrimination and Employment Act of 1967, also referred to as the ADEA, applies to employers with 20 or more employees. And the ADA protects individuals 40 and over from employment discrimination. The Americans with Disabilities Act, also referred to as the ADA, and I apologize for not putting the number there, but it applies if you have 15 or more employees. And it prohibits discrimination against qualified individuals with disabilities. There's also a component in the ADA, it's not just discrimination, but a component of the discrimination is that employers are required to provide reasonable accommodations to employees with disabilities, and it does place a responsibility on the employer to engage with your employees in a discussion about potential accommodations that could be made for employees who are having difficulty performing the essential functions of their job. If the ADA is very complex, it is very fact specific. If you're dealing with one of those issues, I encourage you to contact the Pro Bono Partnership and get some advice on this topic. The Fair Credit Reporting Act, also referred to as FCRA, applies to organizations who conduct background checks. This is a very, very complex statute as well. And again, I mean, I could probably talk for at least an hour plus just on FCRA. But what you do need to know is that it applies when you conduct background checks and you use a third party. It requires a written release by the employee, and if you use information that is covered by the FCRA, then and you make an adverse decision based on information that you do receive, you have to give notice to that employee. And it applies to consumer reports, DMV records, criminal histories. The reason why it's important to give notice to a potential employee of some adverse information is so that if it's wrong, the employee or potential employee has the opportunity to come back and explain why it's wrong, or might be able to explain the circumstances behind the information that is potentially adverse and may prevent them from being hired. The Federal Bankruptcy Act makes it unlawful for employers to discriminate against employees and job applicants because of bankruptcy or bad debts they had before filing the bankruptcy. And there are also state laws that apply to organizations in the context of hiring and termination. Often we'll see claims for negligent hiring, negligent retention, and negligent supervision. Basically, what a negligence claim is that somebody who was injured by one of your employees says, you should have known, company, that this individual had the propensity to engage in whatever conduct it was that caused my injury. For example, if you hire somebody for your organization who drives your company vehicles, for instance, and you fail to run a driver history check on them. And had you run the driver history or their license check, you would have found they had an extensive driving record, which may have precluded their employment, but at least put you on notice of the risk of, if they had 3 accidents in the last year, of their propensity and their risk in engaging in another accident. Tortious interference with business relations. Usually you'll see this claim if an organization or a person interferes with somebody else's efforts to find employment elsewhere. So it's basically a meddling claim. So you do something, maybe you go to a potential employer and you misrepresent information about a former employee, and that person doesn't get the job because of what you said. May give rise to a tortious interference claim. And just as a side note, state laws vary from state to state, so some states may have these laws and other states may not. So just be aware that if you're not in Georgia, which is where this presentation is taking place and where my focus will be today, that if we're talking about state law claims, make sure that you check your own state laws to make sure that they're similar to the Georgia laws. Breach of contract claims would apply if, for instance, you have somebody who is employed pursuant to a contract. In Georgia, we'll talk about this a little bit more in detail. Employees are presumed to be at-will employees. They don't have employment contracts. So the employer can terminate their employment at any time for good reason, bad reason, as long as it's not an unlawful reason. Defamation claims. You'll see them, a lot of times you'll see them from somebody who may not be HR, who may not be trained, may give bad information or false information about a former employee to a potential employer. One of the requirements for a defamation claim is false information. And a defense to a defamation claim is truth. So as long as you're speaking truthfully and generally in good faith, you'll have a decent defense to a defamation claim. In Georgia, there's also a privilege for employers who provide information to potential employers of former employees. Again, it always has to be in good faith in order to protect yourself from liability. Wrongful termination, Georgia does not have a specific wrongful termination claim. I'm also licensed to practice in California, and California does. California has a lot of state law that Georgia does not have that are very restrictive to employers. So again, you may see a wrongful termination claim in a state other than Georgia. And usually that might be something like termination in violation of a public policy. One other thing I wanted to mention too, which is an important federal statute, is USERA, the Uniform Services Employment and Reemployment Act, which prohibits discrimination based on military service in hiring and in employment. Turning to slide 7. Let's talk just generally about some hiring practices. As you go through the hiring process, I want to touch on some of the procedures that you might implement in your organization as you're hiring an employee. Background checks. Background checks are necessary, but the type of background check that you do is really going to be dependent on the type of job that you're hiring for. I mentioned the negligent hiring and retention claims. If you do not conduct a background check, and you should have, you can find your organization liable for a negligent hiring or negligent retention if that employee eventually does injure someone in the course of their employ with your organization. Job specific, depending on the different checks that you do in the background check is going to be job specific. For example, you're not necessarily going to need to run a driving record on an employee who is not going to be driving your company vehicles. You ask an employee, can they get to work? Can they, be at work at a certain time until a certain time? It's really not relevant whether or not they have a driver record. It does become relevant if that individual is going to be driving for your organization. And if you don't conduct a driving record, then again, your company could be liable for negligence if that employee does injure someone in the course of their employment. Before you start a background check, make sure that you get a consent from the applicant to conduct the background check, and it's a good idea, and I highly advise that you notify the applicant of what you're going to do as part of the background check and get a consent and release written form from the applicant. One thing I want you to keep in mind, and if you're an HR professional who does hiring for your organization, write down job related and consistent with business necessity. I have it here on the slide, but one thing that you should always keep in mind in whatever you do is ask yourself, is what I'm doing job related and consistent with business necessity? Because if you can articulate reasons why you're doing certain things, why you're running certain background checks, why you're running criminal histories, why you're running driving histories, why you're making your employees go through drug testing, you will have a better defense later on if you are ever brought to the table to explain your employment decisions. So always keep in mind, job related and consistent with business necessity. And this goes under,
Sorry, I have a question.
There's a question.
Yes. Where's the best place to run a background check on an applicant?
Well, I can't give you particular advice about who you can use, but what I usually advise my clients is to check around with people you know who are engaged in a similar business as you and see who they use. You can also Google around. There's, just like anything, there are going to be organizations who are stellar and then others that aren't so good. So check around, and I would recommend getting a reference from somebody about who can do the appropriate background check. Okay. Job applications. I've seen a lot of job applications. I've revised a lot of job applications, and a lot of times there's information on the job application that doesn't need to be on there, that might elicit protected information such as somebody's age, their race, their religion. This is not information that an employer needs to have when screening an initial job application. if you're using a job application, you might have different applications for different jobs in your organization. I think most people, just because it's efficient, you have a standard job application. But look at it and make sure if you require a high school education for a specific position, and some don't, but maybe it's a factor that you want to weigh in when you're hiring. Don't ask what year they graduated, and you ask why. Why shouldn't I know when they graduated? Well, if somebody follows the normal course of education, their high school graduation year is going to indicate how old they are. So we don't want to know that information. If the high school diploma is relevant, that's all we need to know. Do you have a high school diploma? Same thing with college. Is it job related? Does it matter if the person has a college degree or even college courses? If not, why ask for the information? Another thing that might elicit unlawful or protected information is, are you a U.S. citizen? Now, eventually, we're going to need to know whether or not the individual is authorized to work in the United States, but whether or not they're a citizen is not information that we can have when making an employment decision. All we need to know is whether or not the individual is authorized to work in the United States. Interviews. A lot of times, interviews can be one of those fertile grounds for eliciting protected information. I mean, at that point, if you're doing a personal interview, their gender, their race, that information, is already known to you. But other information that you shouldn't have and you should not elicit during a job interview, what about kids? Do you plan to have kids in the future? This could give rise to a claim for gender discrimination. Where do you go to church? If you're just having a casual conversation with someone and they attend church regularly and they say they went to church, don't ask them, what church do you go to? Because then you're eliciting religious information. So you have to be very conscientious if you are an interviewer about the questions that you ask, particularly if you're over lunch. It's still a job interview until that person is hired. So be cognizant of the information that you're asking. Question.
Yes, question. Is it necessary to know whether a person has been incarcerated?
Well, here we go talking about criminal histories, and I have it a couple bullets down. The thing about criminal histories, you say incarcerated. That doesn't necessarily mean that somebody has a criminal conviction. Now, the EEOC has taken the position, and it's probably a good idea not to base an employment decision on an arrest alone without a conviction, because, again, the EEOC has taken the position that this creates a disparate impact on minority applicants. Statistically, minorities have been arrested at a higher rate. So if you're going to use criminal histories, make sure that you are using conviction information only. Now, if you're hiring for a police department or some other job where it might be relevant, or it might be relevant that the person was arrested, it's not necessarily the arrest you're going to be interested, but the conduct that the person might have engaged in to get themselves arrested. So you really have to focus on the conduct, not the arrest itself. Also with criminal histories, is it really relevant that someone was arrested for public intoxication 20 years ago? So I would advise not to just preclude somebody from employment just based on the sole existence of a criminal record. Look at what the charge is, or look at what the conviction is for. Look at the time span. How long ago was it? How old were they when it happened? For example, if somebody is working in your finance department and has access to money, it would be very important to know whether that or not that person has been arrested or convicted for theft, embezzlement, theft from an employer in particular. Somebody who is not working in your finance department, are those charges or convictions relevant to their job duties? They may or may not be. So don't take the criminal histories at face value. You can obtain them, but evaluate them in accordance with the job duties that the person is going to be hired for. In Georgia, know that there is something that's called a first offender statute, which provides for the discharge of it doesn't even become a conviction after a period of time. So basically somebody gets arrested, they go through the court system, and maybe they're put on a probationary period over 1 or 2 years. And if they pass their probationary period after that 2 years, the conviction is discharged from their record, and you cannot make employment decisions except in very few circumstances based on a conviction under the first offender statute. So, question.
There is a question. If you work with kids and survivors of child sex abuse, this is a little specific, but I think it's a reasonable question. It's if you ask a person if they're a registered sex offender or have ever been convicted of a related sexual related offense. Can you ask those kinds of questions? A lot of our organizations work with children.
Right. Yes. That is relevant to that specific job. And in Georgia, if you don't get that information, I can guarantee you will find yourself subject to some liability. So yes, I think those questions are critical, and that information is critical to know. Again, conviction, and in some cases, maybe an arrest would be something that we can make an employment decision. In very few circumstances, however. And I would agree that checking the sex offender registry is probably a necessary thing.
Do you have to follow FCRA to do that, or can you just go on and look at that? Do you have to let them know you're going to do that?
FCRA applies to consumer reports by third parties. So if you're hiring a company to do your background checks and they are the ones that are providing this information to you, then yes, the FCRA would apply. If you yourself are going on the Georgia Sex Offender Registry and you're doing your own investigation, no, it would not apply. If you were getting a criminal history, however, from the Georgia Center for Information, the Georgia Criminal Information Center, GCIC, yes, FCRA would apply because that would be considered a consumer report. Okay, I know a lot of these things are very complex, and so I just urge you, if you find yourself up against one of these situations, contact the Pro Bono Partnership of Atlanta and have one of their attorneys walk you through this process. Again, my goal is just to get these all on the table so that you can recognize where some of the fertile ground for potential litigation is. Let me see what time it is because I'd really like to. I was doing, after I had agreed to do this presentation, I was looking through the ABA journal, and in April of this year, they had an article called Tales from the Front. And basically, it was just sort of a bullet point of the strangest interview questions you had ever been asked during a job interview. And I just want to read a couple of them because they're kind of funny. Some are appropriate, some are not, and some are unlawful. An interview for an associate position at a mid-sized litigation firm. Are you tough? Because you don't look like it. And then it says, I was tempted to ask if he wanted to see my black belt. Interview at secretarial school for a law firm. I'm sorry, I wasn't really paying attention. Can you tell me about yourself again, please? If you are going to be an interviewer, please review the application, review the resume, familiarize yourself with the individual before they walk into your office, because otherwise it is a waste of time for you and it is a waste of time for them. Another one. Well, since this isn't really a job interview, do you have any children? Unlawful in the job interview context. Do you plan to have kids? This question came from the general counsel of the corporation, a lawyer. Unlawful. And lastly, which some of you may find interesting and maybe even humorous and maybe applicable, for a fairly large and prominent pro-environmental nonprofit. If we have a potluck lunch, what would you bring? Turns out venison chili with a side of cold smoked pheasant was not a good answer. Anyway, I found that amusing. Hopefully you did too. The next bullet, social media. Social media, you can't escape it this day and age. The one thing I do want to say about that is if you use it in your application process, be careful, because you can learn a lot about a potential applicant searching social media like Facebook or LinkedIn. You can learn their age, their gender, and their race. So just be careful if you're using social media in your application process. Make sure that you document what you're doing and make sure that your process is consistent across the board with every applicant. Now, recently, there's been a hot debate about whether or not employers can ask employees and potential employees for information related to their electronic communications and their online accounts, password information, account information for Facebook, for instance, because an employer justifies this by saying, well, I want to know if they're posting information up there that is going to bring discredit to my organization. Well, Maryland just passed a law, I believe it's the first state to do so, which prohibits employers from making applicants and employees disclose names, usernames, passwords, and any other means for accessing a personal account or service through electronic communications. The law, however, also protects employers because it prohibits employees from downloading unauthorized information or data to their websites, and the employer, upon receipt of information about that, can actually investigate it. So this is a hotly debated issue, and I think we're going to see more and more laws, and there's going to be some tightening up about the flexibility of employers to access electronic communications of potential employees. So keep an eye out for that. Reference checks. I've never seen an application that does not ask for references. If you have the information, use it. Make sure that you contact the references, because again, if you could have learned something from a potential reference that would have alerted you to a risk of a potential applicant, and that applicant engages in conduct that you could have known or that you should have known of, then again, it goes back to that negligent hiring claim. Driving history, I think we've touched on that. Make sure that it's job related. Criminal history, we touched on. Sex offender registry, we touched on. Medical and drug testing. Medical testing can only be done if it's done post conditional offer, meaning you have basically done everything else in your background check except for the medical history. This protects against discrimination against disabilities. And frankly, there's probably not a lot of jobs that would even necessitate a medical exam. But if there is one, make sure that you contact counsel to make sure that you're doing it appropriately. You're not obtaining information that you shouldn't have. You should always have a release from the employee. Drug testing. In Georgia, there's a statute that provides for employers to be drug-free workplaces. And you have to have drug testing in place at your workplace. And what it does, it provides you a discount on workers' compensation insurance. But you have to make sure that you're just testing for illegal drugs. When you're drug testing, you can do the illegal drug testing at any time in your process, because that's not protected. Engaging in illegal conduct is not protected. But if your drug testing is going to elicit prescription narcotics, for instance, all of that has to be done post-conditional job offer. Question.
Mm-hmm. So back to the sex offender registry. Are the requirements different with employees versus volunteers?
You can be just as liable for the conduct of your volunteers as you are your employees. So in particular, if you are an organization that has volunteers and employees working with children, the disabled, the elderly, you are going to be held to a higher standard in terms of your background check and what you check for as part of that background check. before you put those people to work. Okay, let's turn to slide 8. Continuing with hiring practices, let's focus a little bit about documentation that might be relevant. The first thing is an offer letter. An offer letter is generally a letter that you send upon an offer, an extension of employment. Your job offer is going to contain the essential terms and conditions of employment. Going back to at-will employment in Georgia, you do not want to, if you want to maintain at-will status of your employees, you need to make sure that employees are aware of that. And I recommend putting it in, you can put it in your application, you can put it in the offer letter, you can put it in your handbook, but you need to make it known that whatever you are doing is not an exception to at-will employment. In your offer letter, be careful not to put a specific length of employment, because that may create an employment contract where you would not otherwise have one. Acknowledgments. Make sure that upon hiring, make sure that you have your new employees sign acknowledgments for receipt of a handbook if you have one. Again, make sure that there is something in your handbook that talks about at-will employment, and that nothing in the handbook is going to create something other than at-will employment status. Make sure you have an EEO policy that talks about the employer does not discriminate or retaliate or harass its employees. For harassment in particular, your handbook needs to have a reporting procedure. For discrimination too, have a central person who is going to be the contact person, or not a person but a position. So if somebody is being subject to unlawful discrimination or harassment or retaliation, there's a particular person in your organization that individual can go to, and you need to make sure that you provide for a way to circumvent a supervisor if the supervisor is the one who is engaged in the unlawful conduct. But at the outset, have the employer acknowledge receipt of the handbook, receipt of the EEO policy, and acknowledgement that they're at-will employees. Acknowledgements are also relevant and very helpful with regard to receipt of the handbook in an unemployment claim, because for unemployment claims in Georgia, the employer has to show that the employee violated some policy of the organization and had notice of the policy. I've run into a couple situations where there wasn't an acknowledgement by the employee, so it became the employee versus the employer, and whether or not the employee was truly on notice of the policy that they were alleged to have violated. So make sure that you have your employees sign that. And anytime that there's an update, also have them sign a new acknowledgement on receipt of the update. Identification and work documents under the IRCA, the Immigration Reform and Control Act. Employers are required to positively identify all employees and ensure that they're authorized to work in the United States within the first 3 days of employment. And so this is upon hiring, the first day of employment. Make sure that you get the required documentation. Tax documents. This again is, I have employee versus independent contractor. This is a beast in and of itself that we could talk on for hours, which I am not going to do today. I just want to alert you to some of the ramifications if you misclassify an employee as an independent contractor. A lot of organizations want to 1099 their employees, basically treat them as an independent contractor when they are truly an employee. There is a very fact-based analysis that you have to go through, but essentially if you're in control of the employee's work, you're going to be deemed an employer, and that person is not going to be an independent contractor. If you misclassify somebody, the potential ramifications that you could be liable for can be significant, because when you have an independent contractor, you're not withholding taxes, you're not paying unemployment. Well, what happens when one of those people gets into an accident, you're not paying workers' comp, gets into an accident, files a claim for workers' comp, all of a sudden this issue about whether or not they were properly classified surfaces. You could be responsible and liable for back taxes, penalties on top of that, criminal offenses, and even personal liability. So if you're thinking about hiring someone as an independent contractor and you're not sure if that person is truly an independent contractor, please, please, please contact Pro Bono Partnership or your counsel. And make sure that you're properly classifying. Another thing to keep in mind for nonprofit organizations who have volunteers, you have to make sure that they're not given any significant remuneration. They're not compensated significantly. You can give them little things here and there, but there's a line that once it's crossed, they become an employee, and you can be subject to liability for certain actions with them. So, and that's always a question too, is whether or not someone is truly an independent contractor. Are they a volunteer? What if you have somebody working for your organization who also volunteers? Are they truly a volunteer? There's just a lot of issues that have to do with classification of employees. So I just urge you to contact counsel, and I just wanted to get that out there on the table. Benefits information. If you're offering benefits, make sure that you fill out the proper documentation. If your employee declines benefits, make sure that you have written documentation that the benefits were declined. Moving on to slide 9, I just want to talk briefly here about employment contracts. I think there is some sense by people, and maybe not, that executive level employees generally have employment contracts, and that is not true. At least in Georgia, you're not going to see a lot of executives with employment contracts. However, there are times when employment contracts could be beneficial to your organization, and you may want to offer one. For example, if somebody has a unique skill set and you want to specify a certain time that individual will be employed by your organization, it might be beneficial for you to lock them in for that period of time. It will be an exception to at-will employment. So upon separation, you need to make sure that you follow the employment contract. Employment contracts have a definite term of employment, and generally they cannot be, an employee cannot be terminated before the end of that contract period. However, sometimes you'll see conditions on termination written in, which may provide for earlier termination. Please, if you're going to use an employment contract and you're going to have conditions on termination, contact your lawyer, because I recently litigated a case where somebody had an employment contract, and the only way that this individual could be terminated was for negligence, fraud, and criminal conduct. So just a policy violation that does not rise to those levels, the employee could not get rid of them. And so here I was litigating whether or not this particular employee's conduct rose to the level of negligence. And that's a very hard thing to do. Employment cases, we try not to go to trial. We try to have a judge rule on our cases before we get to trial, because there's no fact issues. If you're litigating a negligence case, you're going to go to trial if it's not resolved before then. Question.
Yes. So what happens if you hire for term based on a grant? Is that considered locked into the contract period, or does at-will apply? And does that make sense?
In other words, the organization has received grant funding, and as a result, they're hiring this person for the term, for a period of time, and the money for that position is coming out of this grant that they've received or will or are hoping to receive. So the position is based upon this grant money. Now,
and then they're asking, does the person have to be in breach before firing with that particular circumstance?
so the question is whether the at-will, you can include, you've hired the person for a specific term, so you want to have some kind of contract documenting that, and that it's based on this receipt of this grant money.
So
But can you still let them go?
if the grant money expires before that time or something?
Or even if there's bad behavior, things that aren't following the policies, how would you include that?
Okay. A lot of it's just going to depend on the language of the contract. if you have hired someone for a specified period of time and there are no termination provisions in the contract, you haven't put something in there that says that you can terminate for violation of policy, then no, you can't. I mean, you're married to that contract. That person is guaranteed employment for that definite period of time. Hopefully that answered the question.
But it's no longer at will,
Correct.
because you're
That's right.
hiring them for
For
a
a
specific
definite
term
period
of
of
time based on a specific
Yes.
situation.
Yes.
So there has to then be a reason,
Yes. Yes.
and that has to be spelled out in the contract.
Correct.
That those reasons could be for termination.
That
or
is
reason
correct,
for
because it
termination.
will be a breach of the contract by the employee. I think that's the question they were getting at. Yes, okay. Hopefully that answered your question. But yes, when you have an employment contract for a definite term, it is an exception to at-will employment, and you have to terminate pursuant to the contract. So if the employee breaches the contract by violating a policy, if that's one of the termination provisions, then yes, you could fire at that time. But make sure if you're an employer to give yourself some flexibility too, because like I said, what I described earlier did not give the employer a lot of flexibility in getting rid of an employee who deserved to be terminated. Post-termination conditions, these again, restrictive covenants is a very specific area of law in Georgia. The restricted covenant laws vary from state to state. Georgia happens to be more employer-friendly on restricted covenants, which, let me explain if you don't know what that is. It's basically an agreement for the employee not to compete with the organization after employment. So you can enter into an agreement at the beginning of employment saying that after your term of employment, you cannot compete with this organization for 2 years from the date of employment, which Georgia has held 2 years is reasonable. There's also geographic location conditions on it, on what you can do after employment also. The confidential information is specifically defined in the Georgia Code when it comes to restrictive covenants. But you might want to enter into, upon employment, if the employee is going to access confidential or proprietary information of your organization, enter into a confidentiality agreement at the beginning of employment and make sure that that is going to extend beyond employment. With the restrictive covenants, if you're thinking about doing this, make sure that you contact counsel and have someone walk you through that process and that agreement to make sure that it complies with the law of your state and that it will be upheld in court. And that's another area that's constantly changing too and does vary dramatically from state to state. Looking at slide 10, let's roll into termination practices. Now let's talk first about involuntary termination. Somebody is being terminated, usually for disciplinary reasons, misconduct, or maybe even poor performance. As you're deciding whether or not to terminate the employee, make sure that you review their past evaluations and their discipline history. For poor performance, it is good to have a record of counseling about the specific performance issues, and the employer will want to show that the employee has been given the opportunity to cure whatever defect in their performance before making the decision to terminate them. A lot of times what you'll find is just a verbal counseling. I know it sounds counterintuitive. If it's a verbal counseling, you still want to document that the individual was verbally counseled about a specific performance issue, because later on, if that employee files a discrimination suit, for example, against you, you want to be able to show the history of poor performance. The employee was counseled, that the employee had an opportunity to cure. And for discipline, there are some misconduct that will rise to the level of termination the first time. On the other hand, there might be some other policy violations that might warrant a verbal warning or a written warning before the termination decision, or suspension even before the decision to terminate. But before you engage in before you decide to discipline an employee, look at your discipline procedure. Make sure that you follow it. Make sure the employee was on notice of whatever misconduct they engaged in, and ensure consistency with past practice. One of the things for discrimination claims is an analysis of a comparison of the plaintiff, the employee, with other employees of that organization. And if they can somehow show that there were other people who engaged in the same conduct but weren't terminated or weren't suspended, then you may find yourself subject to some liability for discrimination. There's a lot more to the analysis, but that's why we ask that you ensure consistency across the board with how you treat your employees for certain violations. If there's an employment contract, make sure that you review it. Sometimes you'll see in an employment contract a notice period, which requires 60 days notice if you're going to separate an employee. And this would be for like a maybe not misconduct necessarily, but maybe it's just not working out with someone. They have an employment contract, and there's something in there that allows the relationship to end before the contract period. But you have to have a certain, either the employer or the employee has to have notice. Make sure that you give that notice. Termination meeting. Hopefully you're not firing employees over the phone. You want to make sure that you meet with the individual in person. I think there's a tendency, maybe particularly with nonprofit organizations, to want to be sympathetic. I mean, nobody, when you hire somebody, everyone thinks it's going to be this great relationship, and then things sour. And a lot of times you had good relationships with these people, and it's hard to make the decision sometimes to terminate someone's employment. But you want to be honest in letting the individual know why they're being terminated. And if it's for performance issues, it's not going to be a surprise to the employee. And if it's for misconduct, it's probably not going to be a surprise either. But if you're not honest about the reason why you terminated them, if they file a lawsuit against you later and we all of a sudden make up a reason, the employee is going to come back and say, well, that's not what they told me was the reason. And then all of a sudden our reason for terminating them is called into question. So honesty about the reason why someone is being separated is the best policy. Believe it or not, people can handle honesty. It's hard sometimes to be the one to deliver the message, but generally employees can handle it and prefer it. And again, too, sometimes this will thwart off a lawsuit because sometimes you'll see lawsuits where people don't realize, or they say they don't know why they were terminated. And they just want a chance to vent and give their side to the employer. And if you allow them to do that, maybe it will thwart off a claim later on because the person feels that they have been heard and that they were allowed to tell their side of the story. Don't apologize. You made the decision to terminate someone. If you apologize to someone, it might be perceived as some sort of wrongdoing on your part. So just be very fact specific and be honest, and allow the person some time to vent, because maybe that is all someone will need to thwart off a later lawsuit. Turning to page 11 or slide 11. Documentation of separation or termination. Make sure that you document, number one, because again, later on, if we have to explain why we terminated someone, we want to say, look, judge, or look, jury, we documented it, this is what they did, this is the date. A lot of times if you're involved in a lawsuit at a later date, you're not going to remember, maybe the individual who made the decision to discipline is not even going to be at your organization anymore. So you want some evidence of what occurred. So include the date of the incident, the name of the decision maker, the reasons for the termination, and have the employee sign it to show receipt. If they refuse, just put employee refused. But at least it's evidence that we attempted to provide it to, or we did give it to the employee, and we offered it to them for them to sign. Exit interviews. I don't know that a lot of people do this, but it's good practice to always meet with your employees. This is really a chance for the employer to learn specific information about your organization. I mean, if somebody has already made the decision to leave, the chances that they're going to speak more candidly about your organization and their work experience is a lot greater than while they're still within your employment. So this is really just an opportunity for you to learn how to better your organization and maybe learn if there's some things going on that you didn't know about. Return of company property. When an employee is issued certain equipment, have them sign an agreement. Now, in Georgia, in regard to final paychecks and return of company policy, and can you deduct, the amount owed for any property that wasn't returned, Georgia doesn't have any specific laws precluding an employee from deducting money for unreturned equipment on a final paycheck. Georgia also doesn't have a specific law about when that final paycheck needs to be issued. However, it would make sense to issue it within a reasonable period of time. But going back to the company property, enter into an agreement with the employee that they receive certain property on a certain date, that they'll return it upon termination or separation, and anything that's returned damaged or not returned, the value at the time, I guess, and maybe that can be decided ahead of time, will be deducted from their final paycheck. The one thing you do have to make sure that you don't do is deduct so much out of their final paycheck that you don't pay them their minimum wage for the last work period that they were working. Just for security purposes too, make sure that you terminate all password access to computer systems, emails, access codes upon termination of employee, just for the security of your organization. Final paychecks, again, Georgia doesn't have anything with regard to when that needs to be issued. One good practice, I think, is to, if you're going to issue it on the day of separation or termination, have the employee sign an agreement that says that they have been compensated for all time worked. A lot of employers don't do this, and you might have a disgruntled employee who decides later on to file a claim against your organization for a violation of the Fair Labor Standards Act for failing to pay them overtime or minimum wage. You don't generally see minimum wage, but definitely overtime. So if we have something on file saying that we've compensated the employee for all time worked, it's going to be hard for them to come back and say that they weren't properly compensated for their work time. COBRA, if you have 20 or more employees, make sure that the COBRA notice gets distributed, or that you contact your insurance provider or your third-party administrator to make sure that procedure is followed. And that's for continuing benefits. Slide number 12. I got 2 minutes here. Separation agreement and release. Sometimes a separation agreement, or also called a severance agreement, and a release agreement, is an effective tool to avoid litigation down the road. You might want to use a severance agreement if somebody has already asserted some type of claim against your company, if you're willing to pay them something extra than what they're otherwise entitled to in order to get a release from them, not to sue your company at a later date. Some of the things, well, let me just go down real quick here. Consideration has to be given in the course of a severance agreement or separation agreement and release. What is consideration? It is the provision of something to the employee by the employer that they would not otherwise be entitled to. Excuse me. For example, payment of salary for a period of time after their last day might be consideration, because they wouldn't otherwise be entitled to that extra money. And why do we do that? In exchange for the employer releasing any claims against the employer in the future. I don't mean it literally in a sense of all claims. I just mean claims up to the date of termination them bringing those claims at a later date. You cannot release future claims. So it's a release of all claims up to that day. And there are a couple things that you can't release. So if you're going to do one of these agreements, contact legal. There has to be language in there that the employee is entering into the agreement knowing and voluntary. There's usually an opportunity for them to engage their own attorney for review. Again, you're going to want a provision in there acknowledging receipt of all compensation due. And if the employee is 40 or over, and they're going to release a claim under the Age Discrimination in Employment Act, the ADEA, the OBPA is how we say it, has specific provisions that need to be in the severance agreement, which provide for a period of time for an employee to consider the agreement, and there's also a revocation period. So for any severance agreement for a worker that's over 40 has to comply with the OBPA. And real quickly, slide 13, post-termination practices. Unemployment compensation is probably one of the first times that you'll see an employee after separation if they file a claim for unemployment. A voluntary resignation, they're not entitled to unemployment as long as they resign with good reason. Constructive discharge claim is an employee who claims that they were basically forced out. So they voluntarily resigned without good reason. They were coerced, they were forced. And then they would be entitled to unemployment compensation. The employer's burden is to show that the employee engaged in a policy violation, which goes back to the acknowledgement for the handbook. That's something that you will always want to provide to the Department of Labor in defense of an unemployment claim for misconduct, for someone who was terminated for misconduct. Employment references, you might be contacted by a potential employer of a former employee. Make sure that before you release any information, you have a release that's signed by the employee. Be truthful in whatever information you provide. Like I said earlier, being truthful is a defense to a defamation claim, and there's a privilege in Georgia specifically for employers who provide information in the course of a reference check. Central source, basically what that means is have one person in your organization or a department in your organization who is going to be the sole source that's going to provide references on former employees. In record retention, there are record retention laws under federal statutes and under state law. Personnel files in Georgia need to be maintained for 7 years. So all that information is available online through the Georgia Secretary of State website. You can contact Pro Bono Partnership of Atlanta if you have questions about retention time for certain types of documents and files. And the last page. Again, if you have more information about anything that I discussed during this presentation, please contact the Pro Bono Partnership of Atlanta. I thank you for joining us today. I hope this information was helpful to you. Thank you.